Hi, I'm Dawn Hallman, and I'm an estate and tax planning attorney in Oklahoma. And I'm doing a little mini video series just because find that my clients might come to me with a lot of misinformation. Maybe they've researched on the internet, or they have no information and just there's a lack of good information out there. So I'm trying to do a little mini series that will basically transcend through different states and will go across the border so that it won't matter what state you're in and watching this in. Hopefully the information you get out of here is going to be great and useful. And again, sort of caveating this with you're obviously not my client unless you've hired me and now you found the video. So this is just meant to be educational purposes only. Please do not take this as legal advice because again, you are not my client. All right. With that being said, let's dive into power of attorneys, because this is a document that I see sort of misused, misrepresented, or misunderstood very frequently. So there is, in our office, we separate out the general power of attorney and a healthcare power of attorney. So you'll also see the word durable used under the general power of attorney. So durable just means that in the event and I'm just going to call it the client, right, the person who's having this done, the client becomes incapacitated, the power of attorney continues to work beyond the incapacity. And I know, why would you not want it to keep working? That doesn't make any sense because that's when you need it the most. I agree. So if you're a practitioner watching this, please don't ever let your power of attorney just cease to exist if somebody's incapacitated. That malpractice. Anyway, not necessarily malpractice, but it certainly is not best practices. All right. So general power of attorney covers all the day-to-day type things. So what's a power of attorney anyway? Power of attorney is basically a document that says, anything I can do, this attorney in fact, this person that I'm appointing can do for me. So if I appoint my husband as my power of attorney, it means anything I can do, he can do for me. So that means that, if he wants to call my credit card company and cancel the credit card or deal with our home insurance or change our cell phone plan, he can handle all the day-to-day stuff, right? He can just step into my shoes. So imagine power of attorney is a great pair of shoes, and it just lets someone step into your shoes and act on your behalf. General power of attorney can actually work a couple of ways. It can be effective immediately, so right when the client signs it, or it can become effective in the event of incapacity. So we actually call that a springing power of attorney. So imagine like you're alive, obviously alive or they don't work, alive and competent, and here's the power of attorney. It's like hitting this ceiling. Now you become incapacitated, that power of attorney is going to spring up and now it becomes effective. So that's why it's called a springing power of attorney, because the powers spring up in the event the client or the person on there becomes incapacitated. What defines incapacity? Well, it depends. How is it defined in the document? So typically we will define it in the power of attorney document. And whether that's one doctor says you're no longer capable of managing your affairs, or two doctors say you're no longer capable of managing your affairs, whatever that is, it needs to be defined in the document itself. So what does a general durable power of attorney do? Well, it can do just about anything. So the powers listed out in there, when I first started my practice 6 years ago, my general power of attorney, or my power of attorney, was actually one giant power of attorney. It was like 8 or 9 pages. And now that monster has morphed into like 28 to 30 pages. And it's just simply because, the more rules and regulations and things that come out, the more that we're like, hey, we have to have this special release or this special language allowing somebody to still act on my behalf. And maybe I'm acknowledging and consenting to the risks, or maybe it's that I need a special power spelled out. So it's just over time, it's just evolved, right? It just evolves. It evolves with the law, it evolves with the precedents, it just changes. So if you have an old power of attorney, please, please, please have it looked at by your estate planning attorney. Not all power of attorneys are created the same. Okay, so it's very important that you have it looked at. Usually every 2 to 3 years should be sufficient. Or if you have a change, you've changed where you live, you're in a different state, and so forth. So that's important to have that looked at. So general power of attorney, the powers that it will give should be spelled out in the document itself, right? So is it the power to access a bank account? Is it the power to, deal with digital assets? So again, hundreds of powers can be addressed in there. So it's pretty broad of how that's addressed. Now, if you have a trust, like a revocable trust, and your assets are all in the trust, I get this question almost daily. No, a power of attorney does not access, well, typically, I should say, does not access your trust. It's your trustee that accesses the trust. So in the trust document itself, it should say, okay, if I die or if I become incapacitated, again, that should be defined. Then here's who steps in my place to act on my behalf. That's a successor trustee. Power of attorney covers any of the day-to-day type things, right? But so I own my IRA individually, right? Or my pension. So it might be who can deal with that, who can, sign a sign for to get more money every month or change a beneficiary designation or whatever. So that's kind of what a power of attorney can do. But it covers just things that relate to the person individually. And if they have a trust, then it's not going to cover those things unless it's specifically spelled out. But again, you get into some whole other problems with competing documents, et cetera. So typically, most attorneys will not let the power of attorney, like our power of attorney just lets someone fund the trust. So if you find an asset that's not in the trust, that's left out, power of attorney on the client's behalf could sign the asset over to the trust, but it does not give that person the power over the trust assets or the power to make those distributions. All right, so that's a general power of attorney. So again, all the times that they're like, we're sorry, we need to have Mr. Hallman on the phone to approve this, I'm like, what's your email address or what's your fax number? I will send over my power of attorney. And then they kind of have to deal with me just like they're talking to Mr. Hallman, except they're talking to Mrs. Hallman. And so that's kind of what a general power of attorney does. Healthcare power of attorney is just what it says, healthcare decisions. So that covers really all the day-to-day type healthcare decisions. Okay, that's very different than what an advanced directive, AKA a living will, is, or what a DNR is, which stands for do not resuscitate. So we're just going to dissect each one of those one at a time. So healthcare power of attorney is what covers all of the healthcare decisions, like who could call my pharmacist, who could pick up my prescriptions, who could get copies of my medical records, who could at the hospital, if they're operating on my carpal tunnel and they find a problem in my elbow, who can give them consent to go in there and clean that out? Because I didn't consent to my elbow when I went in for surgery. I consented to my carpal tunnel. But this is a person that can make healthcare decisions in real time or at really any other time that need made. So when you go to the hospital or you go to a doctor's office, typically I hear them say, well, do you have an advance directive or do you have a living will? Those terms are synonymous. That means the same. Healthcare power of attorney is different, but living will and advance directive for healthcare are the same. Okay. And for the most part, I think all 50 states have one. I know the majority of states do, if not all. States have reciprocity with other states, meaning if I have an advance directive in Oklahoma, but I'm traveling in New York and I'm hooked up to life support, the doctors in New York can acknowledge my Oklahoma advance directive to take me off life support. So what an advance directive does is it just deals with life support, like I said. And it may be, and again, states are all different. So your state may say like, yes, take me off, or no, don't unhook me. Like those are your two choices. Oklahoma a few years ago came up with a little hybrid approach. So now Oklahoma has options of, no, I do not want to just stay alive on a machine. So if two doctors say there's no chance of recovery, I don't just want to be kept alive on a machine. I want the ventilator, basically in the feeding tube and the IV, the artificial nutrition and hydration removed. There's this little hybrid one now that says, well, I don't want to be kept alive on life support, except I do still want artificial nutrition and hydration. So that's essentially like, I don't want the, whatever it is, respirator, ventilator. I didn't go to medical school. So sorry if you're a doctor and I'm screwing this up, but you get the idea. I don't want life support, but I do still want the artificial nutrition and hydration. So I still want the feeding tube and the IV, but I don't want the respirator or the ventilator. And then there's the third option, which is no, even if there's no chance of recovery, I still want to stay hooked up to life support for as long as possible. And in that document, you will name a healthcare proxy. And again, that's typically the person that can then essentially sign off on it. And I always say, even if you're not sure what decision you want to make, at least leave it blank and sign it so that your healthcare proxy can make that decision. But more importantly, it is important to make that decision so that you are not leaving that pressure of a life support decision on your family. And especially if you have kids that don't get along, which we see in our practice all the time, you don't want them to be like, and you killed mom, right? Like that's not what you're looking for. So it is important so that at least it leaves the family with a warm fuzzy, and it absolutely alleviates some tensions if you say name certain people and not others, right? It alleviates those tensions because then they're just doing what you wanted. And so when you go to the doctor or the hospital and they say, hey, do you have an advance directive or living will? You're like, yes, I have one. But I also, if you have a healthcare power of attorney, want you to pretend like they're married, like they're the salt and pepper shaker. I want them not to get a divorce. They traveled together. So they say, do you have an advance directive? And I'll be like, yes. And here's my healthcare power of attorney. Because advance directive just deals with basically plugging the machine or unplugging the machine. Healthcare power of attorney covers all the other decisions. So living will is just over here, this little life support decision. Healthcare power of attorney is all the other decisions. Also, there is a document called the DNR, do not resuscitate, right? Typically, when a client comes to see me, we don't do DNRs because they're alive, they're competent, they're there. If they, choke on the grape, they want the Heimlich, like they want a chance of survival. Now, a good healthcare power of attorney has the ability to sign, it gives your attorney, in fact, the ability to sign a DNR in the event that one is needed. So for example, I go in for open heart surgery. I've died 15 times in the last 30 minutes. They've resuscitated me, but now I've been gone too long. The doctor can go out there, Mr. Hallman's my healthcare power of attorney, and they can say, do you want us to keep going? What do you want us to do? And he, at that point, could legally sign the DNR because he's my healthcare power of attorney. And my healthcare power of attorney gives him that power, and it has to be spelled out. Now, what are the alternatives to power of attorney? So if you have somebody that's now incapacitated, but they don't have a power of attorney, well, a guardianship is really the only other option that's available. So somebody has to go to court to be appointed that person's legal guardian. And it's guardian over the person and guardian over the property or over the stuff. A lot of times that's the same person. It doesn't necessarily have to be. Also, if you get to the point where life support is then the life support decision, like the DNR decision or the remove life support decision comes up, your typical guardianship, just the regular guardianship, doesn't cover that decision. The guardian has to go back to court and get the judge to essentially approve or sign off on the guardian's ability to make a DNR, to sign the do not resuscitate, or to make the call to remove life support. And so certainly having power of attorney in place is so, so, so important because it not only says what you want to have happen, but it also says who you want to be in charge of having that happen. And power of attorneys are important the minute your children turn 18, right? I always joke with my kids, hey, on your 18th birthday, if you want your present, you have to sign this. I am kidding, sort of. We certainly let them choose their own guardian, their own attorney, in fact. But at the end of the day, if your child is in college and they're, over in California and you're in New York and they get rushed to the hospital, you're going to call New York and you're, across the entire United States away, you're going to call the hospital and they're not going to talk to you because you don't have the legal authority to get their information. They're over 18. And so you have to have a healthcare power of attorney at a minimum in place to be able to get medical decisions. To get medical information and make decisions if you had to for, say, your child. So very, very important to have that in place. Now, if you have adult or children that are incapacitated once they reach the age of 18, you really don't have a choice but to go to court and have a guardianship appointed because somebody clearly has to have capacity, has to have mental capacity to sign power of attorneys. And best practices is that they have two witnesses and a notary. Again, different states have different requirements as far as the execution of them. But hopefully this helped. Hopefully this helped and helped explain kind of what those documents are, when you use them, why they're so important. And if you have other questions or you want to see other topics, again, I'm doing a little kind of limited mini video series here on some things that we get asked in my office quite frequently. So feel free to drop a comment below and let me know if there's a topic you want to see us cover. So thanks so much. Have a great day.